Hi, Steve. I think we can get started. So first of all, I want to thank you, Steve, for taking time today to join us. We are
Thanks for
doing
having me.
we are doing a series of webinars trying to help our existing customers and prospects, trying to understand a lot of these challenges that companies are facing, employees are facing on different topics. And this has been a very interesting topic for a lot of our customers is US immigration, right? There's been a lot of changes over the past few years on a lot of different things. And we see that changes happen so fast that by the time you're up to date on one, there's another change that keeps coming up. So it's been a lot of change and a lot of uncertainty, especially after COVID. We are seeing that there's been a huge shift in terms of the priorities on immigration and the way companies are hiring people, right? So we wanted to take it in two perspectives, one from an employee perspective as well as from a company perspective too. So before we get into details, quickly, I want to introduce myself and I'll give you a chance to introduce yourself, Steve. As quick about me, I'm the current CEO here at Oorwin. Brief background about Oorwin. We are a SaaS-based sales, recruitment, and HR platform. We have customers using our product throughout staffing and consulting industry. What we see, we are one of the most important challenge that our customers have been bringing up is in the topic of immigrations, right? So we wanted to have a discussion with Steve about, to discuss some of these problems that customers are talking to us about and how we can solve these problems as well. Steve, again, if you can introduce yourself, we'll get into Q&A.
Yeah, absolutely. My name is Stephen Brown. I'm an attorney with Reddy and Newman PC in Houston, Texas. We're a immigration law firm, basically mostly focused on immigration law, business immigration, excuse me. My practice areas really are more on the non-immigrant visa side, H-1s, especially H-4s, F-1s. And then I've done some bit on the litigation co-counseling with some outside counsel on some litigation efforts for delays and denials as well.
Perfect. Thanks, Steve. Thanks for joining us here. We look forward to get a little more understanding. Maybe to get started, before I get started, I have a couple of housekeeping things just so that everyone knows. This session is being recorded, so post the session, this will be uploaded on our portal, so it is available to view again if you want to do that. Also, there is a Q&A box over here, so if you have any questions that you want to put in, please go ahead and put them in there. What we'll try to do is at the end of this session, we'll try to spend 10 to 15 minutes discussing those as well. Okay, good. So again, let's just get into, Steve, into the problems and, a lot of uncertainty around, right? Especially in the way, traditionally companies have been hiring resources, especially if tech resources, there's been a lot of dependence on H1 visa, F1 visa, and, H4 visa as well, right? So with this uncertainty right now, what we want to understand is, what do you suggest? For example, a lot of our customers have a lot of employees who are on visa, right? Can you give us some suggestions on what are the best practices that they need to be aware of in terms of to make sure that their existing employees are compliant, or anything that you would suggest at this point of time?
Yeah, so absolutely. So one of the biggest things that you can do, one of the biggest uncertainties right now is with processing times, especially with, or applications that don't have premium processing, like the H4 EAD, F1, and all that. Now the H1 does have premium, but the biggest uncertainty is that processing time. And so my biggest recommendation is to file as early as possible. I mean, if you can file H1s up to 6 months in advance, and I've got, and that's kind of what I routinely do. I've just filed a extension for January of 2021 just recently, because it's just wanting to get in as early as possible in case there's any hiccups. Filing early also allows you a benefit. If there's a denial and you still have a valid I-94, you could possibly retool the petition, instead of having to deal with a denial after. the expiration of the I-797.
Right.
So filing early is the biggest thing. From there, since the IT Serve v. Cisna lawsuit and settlement that came after it, the USCIS is a lot less focused on the employer-employee relationship, and one of the biggest issues up until that settlement was the contracts from all the layers. And so now what the agency's really focused on is three things that we've seen a lot on RFEs is specialty occupation. Does the position qualify as a specialty occupation? Is the beneficiary qualified to perform the position? And then, especially for the CAP cases, we see a lot of status questions. For the specialty occupation, a lot of that's, we've seen a lot of RFEs even for good SOC codes, but to have the success on it, looking at the Occupational Outlook Handbook and the ONET for that position, for that SOC code, and you can kind of determine what is the language that USCIS is looking at, because those are the two biggest pieces. And you can pick a good SOC code, and that helps a lot.
Okay. Thanks for updates, Steve. So just to recap, so I think it's important that, a company start filing any petitions, any extensions at the earliest, as soon as it's possible, as much as 6 months ahead if they can do it, right? So I think that's a very important point. Other thing I know you mentioned is processing times. There is no clarity on that. Do you foresee any change in USCIS process where there's going to be defined timeline, defined process coming in place anytime soon? Do you see that as anything that's going to change?
It's hard to say. I don't think they are going to change anything, as an agency, especially, with the current administration. Obviously, making immigration easier is not a priority of the current administration. Right. No, we have done some lawsuits, especially on H4 EAD, but it works for H1s as well. H4s, H4 EADs have just kind of hit a snag. H1s a little bit tougher just because there's the 240-day rule. But what we look at is that Congress actually in the Immigration Nationality Act put forward some guidance. And it's not, a hard set rule, but it's some guidance on how long things should take to process. And then from there, there's laws that kind of get into what's reasonable after that. For H1s, it is really easy. Premium processing, is a simple thing. For the most part, that's working. We've had a few outliers of cases that were filed early during COVID that are still kind of being wonky with the premium processing, but premium processing tends to work. But no, I don't see them setting hard deadlines. There are ways to kind of work around, with suing, and then with H-1Bs, you have the 240 days after the I-94 expires to continue working. Right. So there's some things on that, but they're not going to set defined processing times outside of the premium.
Okay, thanks for that. So the other question is, there's been a lot of new changes that have come up, especially in terms of putting restrictions. The current administration has put a lot of restrictions on these visas, right? And also larger corporations like the Amazon, the Facebook, the Google, and Microsoft. So they've actually filed lawsuits. Where do they stand, and what is the impact of these lawsuits, and what changes can we expect from?
Yeah, so I believe that the two major, there's kind of been three executive actions to target just immigration. There was a fourth that was if you're coming from a COVID populous area. I don't, that did impact immigration, but I don't see that as an attack on immigration just because that, that fell more into the welfare side. But Presidential Proclamation 10042 and Presidential Proclamation 10052 dealt with immigration bans to kind of in the name of the U.S. economy and protecting U.S. workers. And multiple lawsuits have been filed on those. And my understanding is that it's kind of in a procedural quandary right now because there's at least three that I know of in DC, and they're trying to possibly consolidate them. I know the government wants to consolidate, and I know the one that's really, there's one out there that I'm more familiar with, Panda v. Wolf, that was geared more towards specific H-1B workers, especially people who had approved I-140s, and it was attacking it kind of as applied to those folks. And some of the others are more holistic. And so my understanding is Amazon, Facebook, Microsoft, and Apple have submitted Amicus Briefs, which Amicus Briefs are, they're called friend of the court briefs. And basically they're saying, we have an interest in this. We're not a plaintiff, we're not a defendant, but we have an interest and we want the court to hear what we have to say. And so here's our understanding of the legal issues. And I do think there's a lot of benefit of Amicus Briefs, especially from major corporations like Amazon, Facebook, and Microsoft saying, we need people to work for us.
Right. Yeah, that's good to know. I think there's been another interesting discussion that's been going around on the news is, that there's been a huge shortfall in budget, and there's been discussion about doing a furlough of a lot of USCIS employees. My preliminary view was there was around 13,000 employees that could be furloughed if, the budget was not improved, right? What is the impact of that, and how do we as companies and we as employees, how is that going to impact us?
Yeah, first off, the furlough kind of keeps getting, it's a can that keeps getting kicked down the road. It was supposed to be furloughed on August 3rd. Now they think that they can get them till September, and they're getting more and more receipts in. I will say that I highly anticipate Congress would, if it really does come to furloughing, and it's not really from the immigration side, but you have both sides get a win on this, one side really wants to make sure immigration is continued. One side doesn't want to see 13,000 U.S. employees lose their jobs in this economy. But if it does happen and there is a furlough, I think what we'll see is a longer processing time. And that's going to be the biggest issue that we'll see. It's just going to increase processing times.
Okay, very good. Thanks for that. Also, what we've seen is there's been a lot of some of these newer rules that have come out. There's been, I think the most recent one was there was an increase in the fee structure. Yes. Do you think that's going to cover it? Or do you think that is going to help the furlough being delayed at some point of time?
So that fee structure doesn't take effect until October 2nd of this year. I do think it will help once it's in because it does obviously allow for an increase in money, but that revenue, when they put out the proposed rule, it shows the increase in the amount of times that it takes to adjudicate these, that they've increased their time for, their touch time, if you will. So really that increase in fees is being designed to kind of cover those costs. What they're going to need to see is, if what USCIS thinks that they need is an increase in receipts, more so than anything. And obviously with kind of how COVID is, there's less people that are traveling and needing extensions. And then there's, layoffs and whatnot. But, right now, I do think USCIS is going to end up figuring the money situation out through Congress, or they're going to get the receipts.
Okay. Also, an extension of that question right now is, a lot of employees are on a H-1B visa and who are up for extension. Mm-hmm. Do you suggest that they start filing it before the fees goes up? Is that a good thing to do right now?
Yeah, if you can't, I will say that the fee increase for the base H-1B is up less than $100. It looks like $95. So the base fee goes from $460 to $555. About is that USCIS in the regulation is reinterpreting the presidential or the 50-50 rule. So the companies that have more than 50 employees with more than 50% on H-1B, the original public law that came out on that said that there was a $4,000 fee for the initial as well as extensions. And so USCIS is extrapolating that now for any petition filed by those 50-50 companies to include extensions, amendments plus extensions. Now, just an amendment, you won't have to, but anytime you're asking for an extension, they are looking to charge that extra $4,000 fee.
Okay.
So that especially that's a big one. I know there's some preliminary talks on some litigation on that, but it's going to be tough.
Okay. Also, an extension is another question that we had is for H-1B premium processing. If the furlough goes through, and if employees are furloughed, is there going to be an impact and delay even in premium processing?
It could. It really would depend on how the agency wants to view its priorities. Premium processing is a big cash plus for the agency. I mean, that's $1,440. Yes, it's a quicker timeline, but they're doing the same job that they would otherwise do, and so it's a huge increase in fee, money for them. The question just becomes, how do they want to allocate their resources if they cut 13,000 people?
Right. I want to get into another question that we have is, especially right now with there's been a travel ban across the world, I'm sure, because COVID has changed life for everyone.
Right.
Especially there's been a travel ban for people coming in and out of the country. So how is that impact for someone who's on H-1B? Currently, what is the impact for existing H-1B visa holders whose visa is ready to expire, or who's already expired, or pretty close to get expiry? So what is an impact for them right now?
So the biggest thing to remember is that these the two executive orders, the PP 10042 and 10052, do not impact in the United States. Now, you can still file with USCIS for extensions. You can still do that whole process. The issue becomes people who want to travel, or if there's a status issue, or they have a denial, and now they need to travel. And the biggest issue right now that people are facing is they can't travel internationally either to leave the United States. So there's one of the biggest concerns is how do you solve the problem of they're not in status but they can't leave. And one suggestion we had is filing for a visitor visa. And the big thing with that is to show, look, we're trying. This person is trying. They had an issue. They can't travel, so they're trying. And I think that would help in the long run when they are able to go for stamping. But people in the United States, they can still file extensions and everything.
Right. Also, another question we had that came up was, especially there's been a lot of these RFEs. With COVID, is USCIS providing additional processing time for these RFEs and visa petitions?
They are. Yeah, they are. I don't know the right off the top of my head, but right now I think every RFE that is currently sitting on my desk is subject to an additional 60-day deadline. So all appeal deadlines, I think, all RFEs, notices of intent to deny, notices of intent to revoke, get an extra 60-day extension for your response time. I'm trying to look real quick here to see what period it covers. I know they extended it not too long ago, but it looks, I can't find the link right off the top of my head here, but it's pretty inclusive, I think, of everything that's sitting out there right now. It gets an additional 60 days to respond. I try not to deal with it. I'd like to get them in early, but it is. I have used it, and it is available.
Okay, very good. Also, another question that we had is, a lot of our customers have been working with the federal government, and a lot of their employees have been on visa. And most recently, I think the last week or the week before, there was another change that came out from the administration about a ban on working on federal contracts, right? We want to understand what is that impact, and is that going to impact all these companies as well as their employees?
Yeah, so EO 13940 is the executive order. What is big about this is it's no action right now. It's really what it is it's President Trump telling the government agencies, do your research on this. Tell me how many are on H-1Bs. How is this impacting U.S. workers? Now, there were provisions in there to put forth notice and comment rulemaking on making people comply with LCA regulation and statutes. But with the federal contractors, the executive order right now is information gathering and less of there are no more H-1B government contractors. It's going to require all the federal agencies to put forth those numbers, and then where the administration goes with it is going to be their prerogative. Obviously, I think you're right. I think the goal, at least from a political standpoint, is to try to prevent it. But I think he would have to kind of go through some hoops. I don't think he can just change it with an executive order, although it gets into a big question on,
right,
is it a hiring question or is it an immigration question?
Okay.
So it becomes a very interesting constitutional issue. But right now, there is no impact. It's more he's directing the agencies to get the research done and figure it out.
Okay. That's good. So there's no. So you're saying that currently there's no action required from employee side or even from an employer standpoint at this point.
Yes, sir.
Okay. So I want to move on, and I want to bring up discuss about another topic that came up. Is there's been a fee increase, right, with all these visa petitions. Is that going to be effective for existing H-1B visas also? I know that there's been $4,000 fee increase. Is that also going to be relevant?
Yeah. So the new fee regulation takes part on August or October 2nd, excuse me, and that will be effective for everybody. So from the H-1B side, it has that base fee. So every time you file an H-1B, no matter what you're filing a base fee of $460. That's going to increase to $555 if I'm not mistaken. And then, like I said, the $4,000 fee for the 50/50 companies would be moving forward. Anything filed on October 2nd or later.
Thanks for that update. So, Steve, we want to move on and just talk a little about a lot of these students who are graduating from college, especially immigrant students, because a lot of tech industry is dependent on these resources graduating from these schools. What is so for there's been a lot of speculation in terms of that students cannot take online classes, they have to be on site in their classes. Can you just throw us some light on what these changes have been proposed and what is that impact for existing students as well as incoming students at this point?
Yeah, it's funny you ask. I actually went this morning to double check one of my coworkers' blog, navigateimmigration.com, because she wrote on this recently on the new guidance, because it's changed recently, and a lot of these continue to change almost daily. So originally in March of this year, ICE put out a memo allowing for online learning, and typically under the regulation, you can only have one online course for 3 hours. The rest has to be in person, and that is in the regs. When it came to the fall 2020 semester, ICE said we're no longer going to follow this March exception to the rule. We're going to go back to what the rule is. They got sued by a ton of different colleges, including Harvard and MIT, who was the first one to go, and a bunch of states as well. And as part of a settlement on this, they took back that policy. And so where we stand right now is that students who are continuing their studies that are in the United States, they can do the online course of study. New or initial students who have already been in the United States, they can continue. The question becomes, there's preventions on people who are coming from overseas to study that are doing all online classes. And we've heard, even, to be honest with you, some that are already, having issues with Customs and Border Patrol. One of the biggest things that I always recommend to anybody before anything with student visas is talk to the DSO. The DSOs are the experts, especially for their school. And I always recommend they speak to their DSO before they do anything. Right.
That's a very good point. Also, like you said, a lot of students, we are in August, schools are, pre-COVID, schools would start.
They get ready to go.
You're all ready. You just get your school supplies. You want to get started now.
Yeah, it's time to move into the dorms and get ready to get going.
Yeah, it's all the fun times, but now things have changed.
Right, I know.
So especially for these students who are applying from other countries, what is that impact for them? Because they probably put in their application, they got admitted into these classes, And some of them have an option for classes to start, but do they have an option to come into the United States right now?
If it's all online, I think they will not be able to enter the US if it's going to be 100% online. Now, I will say I've talked to a friend of mine who is works with international students at Texas A&M, which is where I graduated. And she was telling me they're trying to be very accommodating to international students. A lot of these schools are going to a hybrid system, online and in person, and they're kind of giving priority to some of the in-person for international students so they can comply with the immigration.
Right.
And if they don't, one thing, and I know it's not fun, it's not a great option, but you can always talk to the DSO about deferring for a semester. And just say, hey, I'll have my start date be in January, and hopefully by January things are a lot better.
Yes.
But I know that's not an option, a great option. It's not the ideal thing for somebody who's ready to start their life in the United States. But it may be a practical decision that needs to be made.
Yeah, good. Also, another important topic that a lot of people have right now, especially is on terms of layoffs, right? A lot of industries have been impacted, travel, hospitality, and industries which are even dependent on travel and hospitality, right? There's been a lot of layoffs, and especially in terms of immigration, what does USCIS stand on people who've been laid off? Do they expect these employees to just leave right now? Do they have a grace period? If there is a grace period, how much time do they have right now?
Yeah, so there is a 60-day grace period for H-1B workers if their I-94 is valid. So, if your I-94 expires in 90 days or in 30 days, you only have a 30-day grace period. But if you have an I-94 that's valid for a year, and you get laid off, you have 60 days from your last date of employment to where you're considered maintaining status. And so during that time, you can change your status to another visa status. Like I said earlier, B2. If your spouse is on H1, you can change to H4. And then, if you find another job, great. That new employer can file a transfer for you by that 60th day. So the 60-day guideline is there, and it's definitely going to be used right now, I think.
Okay. So that's good to know. I also want to bring up one scenario that came up. Is what happens is if there is an employee who's in those 60 days and they get an offer, but then the offer starts after the 60 days period, what do you suggest they do?
It's a very good question. We actually it is. We were actually debating about this the other day. If our H-1B team was debating this, if the filing counts or if you have to work. And I think it's a very gray area, and I know that's very lawyer speak. But you should try to join during that 60 days if you can. I actually was looking up I wrote an FAQ on the 60-day grace period. It's designed to allow people for job portability. And so it's designed, we would think that it would be best to join, because that's, I think, how the 60-day rule is going to be interpreted by USCIS.
Right.
It might be a violation of status if it goes beyond, so I'd be very cautious about that.
Okay. Is an offer letter considered as a start, or does it have to be the day they start?
I think it would be the date that they actually start working.
Okay. I'm just asking questions just to make sure our listeners also understand that. Right?
Yeah, because it's, I've written an article on the 60-day grace period, kind of FAQ, and then Rahul from our office actually asked me the same question. And our H-1B team had a chat going where we were debating it back and forth for a while about whether the filing would be enough. And I think we concluded that it should be working, the regulation was written for job portability, not just filing portability. So I would recommend trying to work in that 60-day grace period.
Okay. Yeah. Also, another question we had is a lot of employees right now are closer to their I-94 expiry, right? They filed their petition. They have not heard back because of longer processing times. How do they approach this, and what is that they should be doing in these cases?
Yeah, so for H-1Bs, there is the 240-day rule. So with that, if you timely file an extension, and it's very narrow in terms of what we've interpreted the 240-day rule to be applicable to, or which types of petitions are subject to the 240-day rule. It's not subject, transfers are not subject to 240-day rule. Amendments plus extensions are not subject to it. The question just becomes extensions without change or with change, if those are subject to it or not. To be safe, let's say it is. Let's say all extensions without change and extensions with change are subject to the 240-day rules. But you have 240 days from the date your I-94 expires to continue to work.
Okay.
After that, you have to stop working.
Right.
But you can work beyond that. Beyond the expiration for H, I think L's and E's are also in there. Not H4. So H4 EADs cannot. F1s have different rules with if you're applying for STEM OPT. I think that's 180 days if I'm not mistaken. But H4 EADs, they have to stop working. H1B can continue to work for the 240 days.
240 days. Okay. That's good to know. Also, based on, COVID is so uncertain. We hope it'll just go away tomorrow, but
I would love that.
So we can just get back to what we are doing right now, right?
Right.
And one of the biggest thing that everyone's missing with COVID is travel, for sure. People are not able to move from one place to other. Especially a lot of people between countries, who want to go back home, or who went out, want to come back. Is there a timeline on when you see that U.S. consulates will start accepting people to come in for processing, or do they have an option for sending their documents in so that their visas and other things can be processed right now?
Yeah, it's very consulate to consulate. In fact, Department of State has said as much, that they can't even put out guidance on this because each consulate is going to be looking at their regional structures. I know I talked with a guy in Finland the other day, and he was able to get an H4 visa stamp for his daughter at the consulate, but I know plenty of folks in India cannot because the consulates are closed. Right now, it is a very much, it's a safety concern for the consulates, and they're going to take it step by step. I know the Department of State has authorized the consulates to resume processing once they deem it safe, but unfortunately, there's just not a timeline on that. Right.
Also, it's also interesting that, a lot of people who are on visas right now want to travel. They want to go to Mexico or just go around, right? And flights are still on, so there is an option to travel. Would you recommend that folks travel during these times, or what would you? There are some exceptions to all these rules, and there are some places where travel is available. I have, the clients that I work with have had me write emails to them so they could disseminate it to their employees saying, don't travel unless you talk to us, because there's a lot of factors that have to be taken into consideration. Is the consulates open? Is everything good on your immigration side? Are you going to need an amendment? Are you going to be able to re-enter? Where are you traveling? And so I constantly get emails like, hey, I want to travel here, here, and here. What do you think? And, we talk that through. So, I always tell people talk with an attorney before traveling, especially right now. It's very difficult to predict. And like I said, consulate to consulate, they're actually, right before this call, Department of State put out new exceptions to the travel ban that I haven't been able to read through. It was sent on our attorney chat just right before this. I can put that link on the chat, I think, that it came out. Let me get this to all. But, so I always just recommend talk to someone, do some research before you travel. Don't just, don't just travel, do some digging into it, because it's very difficult right now. But I shared just now to all panelists and attendees the new kind of guidance from Department of State on H-1B travel. It does look like that if you're in the U.S. and on H-1B, you should be able to go, re-enter. The problem just becomes, is your consulate open for you to get a visa, visa stamp? Okay, that makes sense. Also, one other topic that we want to talk about for a lot of our companies is lottery right now.
Hmm. Yeah.
I know April, there was a lot of petitions that came in. Can you
Mhm.
just give us a little more updates on where we are with the lottery process and what can we expect, in the next few months as well?
Yeah, so this year was our first year with the pre-registration system. The online system went much smoother than I had anticipated for a government system to go.
Right.
So everybody did their registrations, and then they ran the lottery, and then they were given that 90-day window to file
Okay.
the petitions that ended on June 30th.
Yeah.
I haven't checked the statistics to see where we are on getting all of our receipts in. I just got my last ones in a couple weeks ago. They've been very slow with
Okay.
regular processing receipts.
Right.
There are rumors right now, and I don't know. I know who tweeted it out. I know Greg Siskind is an attorney who's very connected. I don't know Greg's source on it, but he put out something that he's hearing that there's a possibility for a second run at the
Okay.
lottery, that there might not have been enough petitions filed,
Mm.
and that there might be another, they might either rerun the lottery or continue to go down the list.
Right.
We'll have to wait to see what USCIS says on that. And again, it is just a rumor. I don't want people to plan their life around a second lottery.
Yeah.
But it's getting some traction on Twitter and LinkedIn that
Okay.
might happen.
Right. Right. It's very interesting because, there's all these uncertainties on lottery and people are just waiting for an update and they're not getting any
Right.
update. So that's been a big challenge. Also, before we get into too much, I just want to make sure all our listeners know that for some of them who joined late, we have a Q&A box section here on your meeting. And if you have any questions that you would want Steve to help out with or answer, please go ahead and put them in. And then we have 5 minutes before we get into Q&A, Steve. And also, one other area and, a lot of our customers are trying to understand is with L1 visas, right? So, and also these other types of visas. What is that? What is an impact right now on L1 visas, and how can they bring their employees from other regions and other offices to the US right now?
Yeah, so L1s are still subject to the proclamation that the 10052 that applied to most non-immigrant visas. L1 was always the one that I thought was a little weird to be included because those are people who are already employees
Right.
of the company. And they hold such a specific position. They're either an executive or they have that specialized knowledge. So I never understood the inclusion of that.
Right.
But again, the Department of State just put out some new guidance today on L1 and L1B, and that's that link I sent. Like I said, I hadn't gone through it just yet, but it looks like there are a lot more exceptions to it, and they're going to have to L1As are going to have to prove up 2 of 3. L1Bs I think can meet any of the all 3 or any of these, but there's a lot more exceptions now. But they are subject to the same rules as H-1Bs, where I do think if they already had a visa stamp, they're fine. They can enter the United States, assuming with COVID and they're not part of the regions that are precluded. Like I know there's parts of Europe that are precluded
Right.
from entry. But you can stay in another country that's not precluded for 14 days. I gave the guidance to somebody the other day, and he said, I'll go to Turkey for 14 days and then to the U.S. And as right now, that's okay. But yeah, take a look at that link, everybody, that I just sent on the chat. Like I said, they just drastically kind of put out some more guidance on this,
Okay.
like right before the call.
Very good. It's good timing then. We wish
Yeah.
we had this a little before, but perfect. Thanks for sharing all this information. Also, again, I want to open a few questions that some of our folks have put out here. One of the questions that came up is for CAP 2021 regular processing, is there a timeline on the decision right now?
Man, it is all over the place. We had some early filings that got adjudicated quicker than any premium case that were in regular processing. And now I think now that everybody's in, we're going to be kind of seeing a lot longer processing times. Um, my anticipation is that we still have cases pending after October 1st. That's how it's been the last couple years. Since the administration took over, it's been slower. USCIS does post their processing times. If you go to uscis.gov/processing times, you can search by case type and service center to get a guideline. But like I said, you can always upgrade to premium too if you need to.
Okay. Also, there's another question right now is, do you think that Elven extensions will be more difficult now given the proclamation?
I don't handle as much on the L1 side. I do know, talking with our folks that do, L1s have just gotten more difficult under the Trump administration, even more so than H1Bs. H1s, we've been able to kind of find some workarounds, but L1s, I worked on one, had a stack of paper like, this big, and still got RFEs. So
right.
one of the biggest recommendations I always have for L1s is look at an RFE, look at a denial, and you'll see what they're looking at.
Right.
I know that's a horrible way to learn. It's from a denial, but denials do tend to show the agency's thinking a lot more than approvals.
Right. Yes. Yeah, it helps us to understand what is an approach that we can take to make sure that, we are successful, right? To make the approved end of the day. That's what we want to do, right?
Yeah, and I mean, like I said, the denials, I know they're bad, but I always take them as a learning experience. What evidence did you submit that didn't work? What evidence did work? And, try to improve upon that.
Okay, very good. Also, another question we have right now is, what about OPT extensions for F1 students right now? How is that going to be impacted?
Yeah, the biggest issue with USCIS right now is delay. Now, I think with going from OPT to STEM OPT, there is a period of work time. I don't remember the time off the top of my head, but they can continue to work while it's pending. But it is taking a very long time to get those cards printed, even for the initial.
Okay, right.
Also, and that's the biggest thing.
Yeah, we've been also reading a lot about printing of cards, right? That USCIS has been facing a lot of challenges in printing EAD cards, green cards. So where do we stand there right now?
So yeah, that happened. That came out. There was a news story that was done on this, that USCIS lost, didn't renew their printing contract in June with their printing, and then with COVID and kind of the possibility of layoffs, their internal folks are very slow to print. When that article came out, I think there was a backlog of about a month from approval to printing. I think it's gotten a little bit better. There was a lawsuit that was filed in Ohio as a class action for EAD holders, and I think maybe green cards were included in there as well, but I know definitely for EAD holders. And that lawsuit's kind of in multiple phases. So that first phase, the judge granted a temporary restraining order as applied to the named plaintiffs, and ordered USCIS to print the named plaintiff cards in, I think, 7 days. Now the next step is fighting on class certification, and then from class certification, can you get this to apply to the whole class? The good thing about the way that went about with a temporary restraining order, preliminary injunction, is that the burden that the plaintiffs have to show is likelihood of success on the merits. And so, while it's never a guarantee that you're going to win the case just because you want a PI, that likelihood of success on the merits is a very nice legal thing to think about, because it shows that you've at least proven that, hey, there's something here to this that we're right on.
That's great.
So I'm hoping that continues to go smooth. USCIS continues to print. We had run H4 EAD lawsuits for a while. We kind of hit some snags with COVID, but we're hoping to pick those back up here in the next couple months.
Okay, that's good to know. Also, I think we have the next question is, due to current COVID-19 situation, H1B employees are working from home within commuting distance from an end client site. Do they have to file H1B amendment, LC amendment at this point?
That's a great question. That's a great question. I don't know if it is within normal commuting distance. So the Department of Labor guidance and then the SEMIO guidance that USCIS interpreted from Department of Labor and then from some cases that came out. If there is no material change in the job duty, so they're doing substantially the same job, and they move work locations within the normal commuting distance, and there's not a number on that. It's kind of a what is normal is kind of up to the beholder here.
Right.
But if they're working, if they typically live, I live out in Katy, I have a 45 minute commute to the office. If I needed to work from home, I wouldn't need to file a LCA and file an amendment because that was normal commuting distance for me. Right. Now, I don't think you're going to be able to, if I moved up to Dallas, I don't think, going from Dallas to Houston is normal commuting distance. Right. But if you're in the same city, and one of the biggest ways that I look at it, the metropolitan statistical areas, you can search for those by the county. So you'll have the Houston metropolitan statistical area includes a whole list of counties that are underneath it. And that's one way I always look at it. That's a good guidance. If for some reason someone lives and they, especially people that work in New York City tend to live in New Jersey, they're outside of the metropolitan statistical area. That's normal commuting distance.
Right.
So just kind of take a look at it. It's, if you get much more than an hour 15, maybe you're kind of stretching it. But I think if you've lived in that place prior to COVID and worked, I think you'll be okay.
Okay. Also, an extension for that question right now is a lot of companies have moved into a 100% remote role right now, right? So ideally, it's based on wherever your house is, wherever you are living. So is it a problem for employees to move from one city to other? Do you recommend them doing the shift or not to make that shift, but to stay where they are right now?
If you are moving cities, you'll have to file an amendment. And obviously with that, creates any sort of normal concerns that you would have with an amendment. The big thing is if that person is working on the same job that's already been approved and you are doing an amendment because of the work location, I would spell that out on your employer letter. I know USCIS doesn't have to give deference anymore under their MET policy, but I think there is still something to that psychology of, hey, we've already approved he's just moving. That does help. And for new petitions, I've been including both the end client and the home location and just putting a note saying that, hey, with how COVID is, he's working from home, but our long-term goal is to get him to the end client. We're including both. Right.
Even customers are like, a lot of customers too, I've seen companies talking to me about it, is that end client is like they currently want to get the employees to work remote, but at some point when everything, hopefully there's a vaccine that comes out, hopefully magic happens, something happens, and they are asking employees to get back to work, right? So that is still, that as still being there. And I don't think 100% remote is yet active everywhere too right now.
Yeah, so like I said, on most petitions that I've filed in the last couple months, I've been doing a bunch with both the home and the end client location, and just saying, look, this is the USCIS knows that COVID's a thing. They're not living in a bubble.
Right. Also, another question that I had was in terms of, I think there's one more question here. We have a few more questions here. I have an employee with an asylum EAD working with a foreign national visitor card. Our customer CAO does not want our employee to telecommunicate full time because she cannot be supervised. Is there a way out?
I'm going to be honest with you. I'm not sure. I don't handle asylum cases at all. So I don't want to give a wrong answer here on this. I will say that one thing that I've always told clients, even from the H-1B side, if your customer doesn't want something, I mean, unfortunately, you got to work with that. If they don't want the guy working from home, even though he can under H-1B rules and regulations, I've always said, you got to, the customer is going to set their ground rules. So Scott, I apologize. I can't answer that. if you want to shoot me an email, I can try to talk to someone who might, but we don't handle a lot of asylum cases in our office, unfortunately.
Okay, very good. Good. So again, I had one last, I wanted to ask you, I think we have one more question that just came up. So no, we don't have. So other thing that we wanted to just do a recap on, what we discussed today, especially on these uncertain times with a lot of changes that are happening. What you would recommend right now is, based on all our understanding, is that, if there are any employee visa petitions that need to be filed, to be upfront, do it as soon as you can, be it 6 months or whenever you can, right? As soon as possible. Even from an employee standpoint, make sure that you are compliant, make sure your extensions are filed, if you're a student, make sure, you're compliant, you're attending your classes, online classes. Also, it is important that, I know that there is no right answer right now because we are all navigating through these uncertain times. Hopefully that, everyone is safe right now, and making sure that even when they are traveling to customers, they're just taking care of, all these things that they need to do. Uh, Ideally, if I would have to recap everything that we discussed right now, do you have any other suggestions that you would want to give, all our employers as well as employees on what's the best practices and how do we approach these situations right now?
Yeah, and I think that you're right. I mean, it's all so much going on the fly right now. I know guidance continues to change daily. Even from my end as an attorney, I got on Twitter as an attorney, because I see things pop up on Twitter, other attorneys pointing out. LinkedIn is great, connecting with lawyers, immigration lawyers on LinkedIn. From multiple firms. I mean, so you can see the thing, and just staying on top of things, setting alerts for USCIS things, Department of Labor alerts as well. And I think because it keeps changing and it keeps changing rapidly, you just need to stay informed. Knowledge is power right now. The I-9 rules keep kind of changing. The LCA posting, all that stuff keeps getting new and changing as things go on. So I would, staying informed is the biggest thing, and doing webinars, Twitter, all that is great. Just make sure you're getting the right people. Like I said, I get my information a lot from lawyers more so than employers, or my friend said that he did this because what works for one doesn't always work for the other. But staying on top of it, and like Venkat said, just file early. It'll allow you to kind of work through some of the problems.
Perfect. And Steve, before we wrap up, I think there's one last question that just came up, and I want to make sure we answer this. The question is, how do we handle RFE wherein the bachelor is not related to IT field? Example, if it's an MBA, BA, or MBBS, and the beneficiary is working in an IT company, can we get approval for this with proper relevant response to an RFE?
Yeah, it is possible. What you're going to want to do is, if it's a straight beneficiary qualifications issue, there are evaluation companies that are out there that can do experience evaluations. My recommendation, pay the extra money to get a university. From these evaluation companies, they can do internal or from university professors, and the professors have more weight. And what you do is submit experience letters. So the employee can collect letters from previous employers saying that when Stephen worked here, he worked here from this date to this date, and here's what he did during this time. And that you as the employer, if you've employed that person, you can submit those letters as well. And the evaluation company, through their professors, can evaluate what the degree plus experience equals. So the equation is 3 years of experience equals 1 year of education. I don't necessarily think that that's accurate. I think I get more knowledge from the job than I do from school, but that's the equation USCIS has. So if you can show more experience and you go with these, you can get, I took someone who had a pharmaceutical degree but had 10 years of experience, and we were able to qualify them that way. Because a lot of the basic courses, those first couple of years from the bachelor's, are universal courses before you get into the majors. So there are a bunch of evaluation companies out there. some are better than others. I wouldn't, so do take a look at them. But it's definitely possible. A lot's just going to depend on how much experience the employee has.
Right. Perfect. Good. So again, before we wrap up, Steve, we really appreciate you taking time to talk to us today. I think we've got a lot of feedback today. The session has been very informative, and people have liked the session. Again, thanks for your time. We look forward to working with you soon. But again, thanks for all your help right now.
Yeah,
thanks.
Absolutely. Thank you all for having me. Anytime you want me to join, let me know.
Sure, we will. Thanks, Steve. Thanks, everyone. Thanks for
All
joining.
right, thank you all.
Thanks. Bye.